In the entire history of the Supreme Court's relationship with American presidents, few moments carry the constitutional significance of what transpired this week. The court, in a decision remarkable both for its unanimity and its velocity, denied Donald Trump's emergency appeal seeking to halt criminal proceedings against him. The swiftness itself speaks volumes. Within minutes of the decision's release, legal scholars across the ideological spectrum recognized it as what it unmistakably is: a complete and irreversible collapse of Trump's fundamental legal strategy. The highest tribunal in our constitutional system, including 3 justices whom Trump himself elevated to the bench, delivered not merely a rejection, but what can only be characterized as a resounding, unanimous repudiation. This was not a 5-4 decision with careful concurrences and passionate dissents. This was not even a 6-3 ruling with predictable ideological fault lines. This was a shutout. 9 justices, appointed by presidents of both parties, finding Trump's emergency request so lacking in merit that not one dissenting voice emerged. George Frederick Will, that Pulitzer Prize-winning conservative columnist who has shaped Republican intellectual discourse for half a century, appeared on national television within an hour of the ruling. His assessment carried the weight of institutional conservative judgment accumulated across decades of careful observation. Will declared in terms that left no room for ambiguity that Trump's legal strategy had completely and irreversibly collapsed. Coming from a man who dedicated his career to building and defending conservative principles, who advised Republican presidents and counseled countless conservative politicians, such words constitute more than commentary. They represent a verdict from the conscience of traditional American conservatism. In the annals of American political strategy, there exists a fundamental truth that seasoned practitioners understand with crystalline clarity. The party that controls the White House rarely maintains its congressional strength through the crucible of midterm elections. This is not conjecture. This is not partisan optimism. December found Donald Trump not in Mar-a-Lago's gilded corridors, not in the Oval Office's stately confines, but rather in a ski resort in the Poconos. He was not there for Pennsylvania's lovely mountain scenery or the recreational pleasures of winter sport. No, the president appeared at this particular venue because he possesses something his critics often underestimate: an acute political instinct for vulnerability. Trump and his advisors are acutely aware of what the electoral calendar portends. They understand with the clarity that comes from hard-won experience that the Democratic Party's hopes for reclaiming the House of Representatives begin precisely where they faltered in 2024. In those narrow margin districts where Republican victories were measured not in comfortable pluralities, but in percentage points that could fit comfortably within a margin of error. Consider Pennsylvania, that perennial political battleground where the fate of nations is often decided. 3 Republican congressmen sit in seats that can only be described as precariously held. Rob Bresnahan secured his Scranton seat, just up Interstate 380 from Trump's December appearance, with a mere 50.8% of the vote. In the Lehigh Valley encompassing Allentown and Bethlehem, Ryan McKenzie prevailed with 50.5%. In the Harrisburg area, Scott Perry, that controversial figure who has weathered numerous political storms, eked out re-election with 50.6%. These are not mandates. These are whispers of approval in an electorate balanced on a knife's edge. Chris Matthews, that veteran observer of American political theater and host of Hardball, on Substack, puts it succinctly in his recent analysis. Democratic victories in those Pennsylvania districts alone could catalyze what Matthews and other seasoned watchers are predicting: a nationwide sweep of 30-plus seats in the coming fall elections. Such a reversal would fundamentally alter the trajectory of Trump's second term, a presidency that Matthews characterizes without apparent hyperbole. To understand the magnitude of this defeat, one must first grasp what Trump's legal team was attempting to achieve. According to multiple legal analysts and reporting from Politico, dated January 7th, Trump's lawyers filed an emergency application with the Supreme Court seeking to halt proceedings in his federal election interference case. This represented, in the assessment of seasoned legal observers, Trump's last realistic hope for delaying his trial until after the November election. The legal theory undergirding this emergency appeal was breathtaking in its scope and audacious in its implications. Trump's attorneys argue that a former president cannot be criminally prosecuted for actions taken while in office, a sweeping immunity claim that would, if accepted, essentially place presidents above the law, not merely during their tenure, mind you, but in perpetuity. A president could commit crimes while wielding executive power and then, upon leaving office, claim eternal immunity from prosecution. The constitutional ramifications of such a doctrine would fundamentally alter the architecture of American governance. It would grant presidents what the D.C. Circuit Court of Appeals aptly termed a lifelong get-out-of-jail-free card. The only available remedy for presidential criminality would be impeachment, a mechanism that has proven in our era of tribal polarization nearly impossible to complete successfully. The court rejected this application according to the order itself without a single noted dissent. Consider that formulation carefully. Not one of the 9 justices, including Clarence Thomas, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett, all appointed by Republican presidents, thought Trump's emergency request possessed sufficient merit to warrant further consideration. One might reasonably inquire, why does George Will's reaction to this ruling carry such enormous weight in conservative circles? The answer requires understanding Will's unique position in American political discourse. Will has served as the intellectual conscience of American conservatism since before Ronald Reagan assumed the presidency. He won the Pulitzer Prize for commentary in 1977 when Gerald Ford occupied the White House, and Jimmy Carter was ascending. He became a founding panelist on ABC's This Week, shaping Sunday morning political discourse for generations of Americans. He wrote speeches for Republican presidents and provided counsel to countless conservative politicians, navigating the complexities of governance. This is not some progressive commentator experiencing schadenfreude over Trump's legal misfortunes. This is not a never-Trump Republican who opposed him from the beginning and now claims vindication. This is a man who built his career on articulating and defending conservative principles: limited government, constitutional fidelity, institutional respect, the rule of law. When George Will speaks, the old guard of the Republican Party, those who remember what conservatism signified before Trump reshaped it in his image, listens with attention born of respect. And what Will articulated on Fox News within an hour of the Supreme Court ruling should, as the saying goes, send shivers down the spine of every Trump defender still clinging to legal fantasies. Will stated, and these are his precise words, "What we witness today is the complete evaporation of a legal fantasy. The notion that a president, having lost an election, could attempt to retain power through extra-constitutional means and then claim immunity from prosecution was always constitutionally absurd. Now it is legally dead. The Supreme Court's denial transcended mere procedural setback. According to CBS News reporting, the court's order included language that specifically rejected Trump's core legal argument with unusual directness for such a terse ruling. The unsigned order stated that the application failed to demonstrate that the petitioner is likely to succeed on the merits of his immunity claims. In the carefully calibrated language of judicial opinions, this constitutes a devastating assessment. The justices were not saying they needed more time to consider the question. They were not expressing uncertainty about novel constitutional territory, requiring careful deliberation. They were telegraphing with as much clarity as procedural propriety permits that Trump's argument lacks merit. Legal analyst Jeffrey Toobin, appearing on CNN shortly after the ruling, called it the most definitive rejection of presidential immunity claims in American history. That assessment, while perhaps susceptible to charges of hyperbole, captures an essential truth. Never before has the Supreme Court so swiftly and unanimously rejected a former president's claim to be above the law. The court's brevity itself carried meaning. When justices encounter genuinely difficult constitutional questions, they typically grant certiorari, hear oral arguments, deliberate at length, and issue comprehensive opinions explaining their reasoning. The fact that they did none of these things, that they instead issued a terse, unsigned denial, suggests they viewed Trump's immunity claims as so fundamentally without merit that extended consideration would serve no purpose. This Supreme Court rejection fits within a broader pattern that has characterized Trump's relationship with American institutions. Time and again, Trump has demanded absolute loyalty from institutions and individuals, only to discover that the Constitution and the rule of law ultimately refuse to bend to his will. Consider the instructive case of William Barr. Barr emerged from retirement specifically to serve as Trump's Attorney General. He wrote the memorandum that framed the Mueller report in the most favorable possible light for Trump. He intervened in cases involving Trump allies Roger Stone and Michael Flynn, reducing recommended sentences and dropping charges in ways that scandalized career prosecutors. By any reasonable measure, Barr was one of the most loyal attorneys general in modern American history. Yet when Barr investigated Trump's claims of widespread election fraud in 2020 and found them baseless, he said so publicly. According to Jonathan Karl's reporting for ABC News, Trump exploded at Barr in the Oval Office, screaming accusations of betrayal. Barr resigned shortly thereafter, and Trump has attacked him viciously ever since. The sin was not disloyalty, but rather adherence to truth over political convenience. Then there was the Supreme Court itself during the 2020 election challenges. Trump and his allies filed over 60 lawsuits challenging election results in various states. They approached the Supreme Court multiple times, confident that the 3 justices Trump appointed, representing a third of the current court, would deliver for him. The court rejected every single election challenge, often unanimously, frequently, without even agreeing to hear oral arguments. We cannot examine this pattern of institutional resistance without addressing what transpired with Michael Pence. Pence spent 4 years as perhaps the most deferential vice president in modern memory. He defended Trump through the Access Hollywood tape scandal, through Charlottesville, through 2 impeachments, through every controversy imaginable. He served as the bridge between Trump and evangelical voters, between Trump and traditional conservatives. But on January 6, 2021, when Trump demanded that Pence exceed his constitutional authority and unilaterally overturn the election results, Pence refused. He refused because the Constitution granted him no such power, regardless of what Trump insisted or threatened. For that act of constitutional fidelity, Trump turned a violent mob against him. Rioters chanted, "Hang Mike Pence," while Trump, according to testimony before the January 6th committee, watched television and expressed support for the sentiment. Pence's entire career of loyalty meant nothing the moment he chose the Constitution over Trump. Even Mitch McConnell, after voting to acquit Trump on procedural grounds following January 6th, took to the Senate floor and declared Trump practically and morally responsible for the attack on the Capitol. McConnell had spent years accommodating Trump, pushing through his judicial nominees, blocking Democratic legislation, and advancing shared Republican goals. Yet even McConnell recognized that what happened on January 6th crossed a line that couldn't be defended. What precisely are the allegations that brought Trump to this moment of legal peril? The federal indictment brought by special counsel Jack Smith alleges that Trump engaged in a multi-pronged conspiracy to overturn the 2020 election results, despite knowing his fraud claims were false. According to the indictment, Trump pressured state officials to alter vote counts. He organized fraudulent elector slates to submit certificates, falsely claiming he had won states that Biden carried. He pressured the Department of Justice to declare the election corrupt without evidence. He pressured Vice President Pence to refuse certification of the electoral votes. Each of these actions, prosecutors allege, was undertaken with full knowledge that his claims of widespread fraud lacked foundation. This is not a case about political differences or policy disputes. This is a criminal prosecution alleging that Trump knowingly attempted to remain in power after losing an election through means that violated federal law. Trump's initial legal strategy appeared, at least superficially, to be succeeding as a delaying tactic. His lawyers filed motion after motion, appeal after appeal, challenging everything from venue to the judge's impartiality to the fundamental constitutionality of prosecuting a former president. According to MSNBC's legal analysis, Trump's team filed more pretrial motions in this case than in any federal criminal prosecution in recent memory. The strategy was transparent. Delay until after November. Win the election, reclaim executive power, and make the prosecutions disappear. But the courts weren't buying it. Judge Tanya Chutkan denied motion after motion, often with pointed language criticizing the defense's arguments as meritless. When Trump's team appealed to the D.C. Circuit, that court not only rejected his immunity claims, but did so in a sweeping 60-page opinion that eviscerated his legal reasoning. The appeals court wrote that the president is not above the law, and that accepting Trump's argument would grant presidents immunity for any crime, including attempting to stay in power after losing an election. Such a doctrine would be antithetical to the most basic principles of American constitutional governance. Trump's lawyers were confident the Supreme Court would at least pause the proceedings while considering the immunity question. After all, this represented an issue of first impression, a legal question never before definitively decided. Surely the justices would want time for oral arguments and a carefully reasoned opinion. That process could consume months, pushing the trial well past the election. But the court said no. Not merely no, but an immediate, unanimous no that suggests the justices saw Trump's claims as so lacking in merit that they didn't warrant extended consideration. This left Trump's legal team in an impossible position. Consider the predicament facing Trump's attorneys. On one side, they must maintain the support of Trump's base, which means projecting confidence and claiming persecution. According to a YouGov poll from January 3rd, 71% of Republican primary voters believe Trump is being unfairly targeted by politically motivated prosecutors. Any lawyer who publicly acknowledges the weakness of Trump's legal position risks being fired and attacked. On the flip side, they must actually defend Trump in court, where judges remain unmoved by political rhetoric. They require actual legal arguments grounded in precedent and constitutional text. Their strongest argument, presidential immunity, just received a unanimous rejection from the highest court in the land. An effective legal defense at this juncture would require Trump to do things he seems constitutionally incapable of doing. It would require acknowledging wrongdoing, expressing remorse, perhaps cooperating with prosecutors in exchange for leniency. But Trump's entire brand, the foundation of his political identity, rests on never admitting fault, never backing down, never showing weakness. He cannot psychologically accept that he lost the 2020 election, much less that his attempts to overturn it were criminal. So his lawyers remain caught in a bind. Please Trump through aggressive defiance that doesn't work in court, or pursue strategies that might work legally but would infuriate their client and probably result in termination. This Supreme Court decision is causing tectonic fractures within the Republican Party. If the court, including 3 Trump-appointed justices, has unanimously rejected his core legal defense, what does that signify for Republican officials who have spent years defending him? Moderate Republicans attempting to balance their constituents' MAGA enthusiasm with concerns about electability and governance now occupy an extremely difficult position. The Supreme Court just handed Democrats an enormous talking point. Even Trump's own appointees rejected his immunity claims. That argument carries particular power because it neutralizes the partisan witch hunt narrative that Republicans have deployed. How can one credibly claim partisan persecution when the justices Trump himself elevated to the court unanimously rejected his position? Meanwhile, MAGA true believers are doubling down. According to social media analysis from Media Matters, within hours of the ruling, Trump supporters were attacking the Supreme Court as part of the deep state conspiracy against their leader. Some called for impeaching the justices Trump appointed. The rhetoric is becoming increasingly detached from legal reality, which may energize the base, but doesn't help Trump in court and alienates persuadable voters. Representative Marjorie Taylor Greene suggested on social media that the Supreme Court has been compromised and called for patriotic Americans to make their voices heard. Such language suggesting that the highest court in the land is illegitimate when it rules against Trump is genuinely dangerous. It represents the same logic that animated January 6th. At the heart of this case lies a question of profound constitutional importance. Can a president commit crimes while in office and then claim immunity from prosecution in perpetuity? The Supreme Court, the D.C. Circuit, and Judge Chutkan have all answered with an emphatic negative. If Trump had succeeded in his immunity claims, it would have fundamentally altered the balance of power in our constitutional system. Presidents could commit any crime up to and including attempting to remain in power after losing an election, with no fear of legal consequences. The only remedy would be impeachment, which has proven nearly impossible to complete successfully in our polarized era. But the courts have now established clearly that former presidents can be prosecuted. This doesn't mean it will or should happen frequently, but it means the ultimate check on presidential power, the criminal justice system, remains available when a president's conduct is truly egregious. According to legal scholars, this represents one of the most significant developments in presidential accountability since Watergate. And even Richard Nixon was never criminally charged. Looking ahead to November, the political ramifications are substantial. According to a CBS News poll from January 5th, 62% of Americans believe that if Trump is convicted of a felony, he should be disqualified from holding office. While the Constitution doesn't actually require disqualification, public sentiment matters enormously in democratic politics. Independent voters, in particular, express deep discomfort with voting for a convicted felon for president. If Trump faces trial during the primaries and is potentially convicted before the convention, the Republican Party will confront an unprecedented situation. Republicans face an agonizing choice: stick with Trump through trial and potential conviction, risking electoral disaster in November, or attempt to pivot to another candidate, risking a MAGA revolt that could fracture the party irreparably. George Will addressed this constitutional moment directly in his Fox News appearance. He noted that what we are witnessing is not simply a legal defeat for one man, but a stress test for American constitutional governance. Will observe that Trump's response to this ruling and the response of his supporters will reveal whether the Republican Party remains committed to the rule of law or has devolved into something unrecognizable. Coming from a lifelong conservative, that constitutes a devastating indictment. The Supreme Court has spoken with unusual clarity and remarkable unanimity. The trial is coming. Judge Chutkan has issued an order indicating proceedings could begin within weeks, stating that the defendant has exhausted his appellate remedies regarding the immunity question, and there is no legal basis for further delay. She noted that Trump has had every opportunity to raise constitutional objections, and that every court to consider them has rejected them. The time for delay, she wrote, is over. We are witnessing a moment that will be studied in constitutional law courses and history seminars for generations. The question before us transcends partisan politics or personal opinion about Donald Trump. The question is whether we maintain a constitutional system where presidents remain accountable to the law. If Trump faces trial and is held accountable for his actions, it will affirm that American democracy, for all its flaws and strains, still functions. It will demonstrate that our institutions, tested as never before, ultimately held. If somehow he escapes accountability, either through legal maneuvers no one has yet imagined, or by winning the election and making prosecutions disappear, it will send a very different message about the constraints on presidential power. The stakes, as George Will observed, could not be higher. The Supreme Court has ruled. The walls have closed in. And for the first time in American history, a former president will face a jury of his peers for allegedly attempting to overturn an election. The evidence now proceeds to trial. The outcome will determine not just Trump's fate, but the future of presidential accountability in the American Republic.